The topic today is national security, and to find out how well the major parties balance security with civil rights. And our speaker today is Professor Faisal Kutty from the Valparaiso University Law School and the Osgood Hall Law School. We'll hear more about our featured speaker in a minute, but welcome to him and to Raja Houri, who's the president of CAI. As I mentioned, this is a collaborative effort between our two organizations, and this is an important groundbreaking campaign to engage and educate Canadians in this campaign, knowing that a lot of the issues that we care about are front and center in the debates. I just wanted to tell you a little bit about NCAR, the National Council on Canada-Arab Relations. It's an organization that's based in Ottawa, has been around for about 30 years, and its main goal is it's an educational charitable organization. It consists of Canadians of diverse backgrounds, including Arab Canadians, French Canadians, English Canadians, all kinds of Canadians who have an interest in the Middle East and the Arab world. The objective is to build knowledge and ties between Canadians and the people of the Arab world to have better relations and cooperation with them. Some of the activities that we do include bringing in speakers, having panel discussions. We have an excellent set of magazines called Perspectives magazines, which are basically our media team curating all the best articles as they appear in Canadian media, but also in international media. So we do all the work for you. It's free. It saves you time. I encourage you to look up these magazines and take a look at them. We've just launched a new magazine for the Canadian elections, so anything appearing about our issues of interest in the Canadian election discussion and debate, whether it's by politicians or media, we're capturing them there. So please do check those out, and please share them as well. We also have parliamentary interns that serve during the summertime, are members of parliament, and this is an excellent career booster and an educational opportunity for them as well. And it also helps to build relations with parliamentarians. So now I'm going to pass it on to Raja to talk about the Your Voice campaign and about the Canadian Arab Institute.
So, quickly for those of you who are not familiar with the work of the CAI, this is our third year of operation, and our vision is for an empowered community, engaged community, in a respectful and inclusive society. So we work both with the community and with the sort of Canadian public, focusing on three areas specifically of work. One is policy, where we do research-based policy papers. On education, and that is educating the Canadian public, particularly influencers, opinion makers, on Arab culture, on Arab history, on Arab realities, through a variety of means, ranging from concerts and museum exhibits to lectures and conferences and the like. And lastly, it's the community engagement part of our work that really is about improving our ability as a community to be present, respected, visible members of Canadian society. And we do that with a lot of emphasis on Canadian youth, through professional networking, as well as with an entire development program for our youth. So we wanted to take advantage of this election year to reach out to the community and engage the community in this democratic exercise. This is a totally nonpartisan effort, and we want it to be that way because we don't want this exercise to be about any particular party or platform or policy. More so, it is really about our community getting engaged in the democratic process. And it's a spring point. It's the beginning, it's not the end. the after election day is really when the hard work will start, and that is to get our community engaged on an ongoing basis in politics and civil society and the various institutions of the country, and because that's the best way for us to become visible and to have a place in this in this country that is recognized by fellow Canadians, and that has nothing to do with the headlines. And the headlines, we all know what the headlines bring. You know, they're never pleasant. So we started this this campaign in June, in late June. We released an Arabic version of O Canada, professionally recorded with a professional singer. You can see the picture at the right-hand bottom of the screen. That was the recording of it, and the idea there was to get our community to pay attention that there is a, this is an election year. There is a there's opportunity here to engage as citizens. You know, many of us do not appreciate the meaning of citizenship. Many of us are recent immigrants. We've come from countries that do not know what democracy looks like and feels like. We're not familiar with being citizens. We've come from areas where we're more subjects than citizens. So citizenship is a very meaningful thing in a country like Canada, and it starts with a vote. You know, in a democratic society, if you don't vote, you don't exist. So the beginning is the vote, and that's why we're focusing on this election campaign as a way to get people starting to think about being involved in the democratic process. So we've done panels. We've gone to everywhere where the community was gathering. We've released videos, animated videos targeted at youth, social media, and so on and so forth. All trying to get the attention of the community, that that there is an election campaign. Faisal Kutty is an associate professor and director of the international law program at Valparaiso University Law School in Indiana, and an adjunct professor at Ascot Hall Law School of York University. He is a co-founder and currently serves as a counsel to KSM Law, Toronto-based law firm. He is a regular commentator on anti-terrorism law, national security, Islamic law, constitutional law, human rights, and Muslims. He has been quoted in numerous academic and non-academic publications and by media outlets around the world. His op-eds have appeared in the Toronto Star, National Post, Global Mail, Al Jazeera, Arab News, Al Ahram, Indian Express, and numerous other publications. He also blogs at the Huffington Post. I've known Faisal since the early days after 9/11. When we were brothers in arms in the civil rights movement. Fighting against racial profiling, religious profiling, civil rights of the Arab and Muslim communities. And sadly, we're still fighting that battle, Faisal. But you know what? I mean, that's what it means to be a human rights defender, and we're really happy to have you with us tonight. You're one of the best voices to speak on this subject in the country, and I welcome you.
Thank you very much. Thank you very much for organizing this and having me participate. Can you hear me well?
Very well.
Okay. So again, thank you very much for putting this together. What I want to do is probably break down the presentation to basically four categories. So what I wanted to basically, I'm going to talk about four different pieces of legislation. There's lots more out there and a lot more in the pipeline, but I think for the focus of this presentation, I'll touch upon the first one, which is the Strengthening Canadian Citizenship Act. And I will also talk about the Anti-Terrorism Act 2015, known as Bill C-51, as well as the Zero Tolerance for Barbaric Cultural Practices Act. I'll just briefly touch upon that. And the fourth piece of legislation or bill is the Oath of Citizenship Act. So these are the four things I'll try to talk about, and then in question and answer session, I can address other things that you may have on your mind. But I do have a piece written which profiles for the past year what legislations, which cases have impacted on the community or will impact on the community, and I'll share that later on with the group. But basically, to start talking about the Strengthening Canadian Citizenship Act, this was passed in June 2014 and had some troubling provisions. Uh, One of the main areas it deals with the grant of citizenship. And granting of citizenship, what it did is it tried to tighten it in some ways, but in so doing, the act made it very inflexible. And there's a number of things that are problematic with when you're applying for citizenship itself. And there's a number of them which is too difficult to go into all of them at this stage. But two that particularly stand out on this uh, is the issue of intent to reside. So this act basically says when somebody applies for citizenship, they have to prove the intent to reside in Canada. At the surface, of course, it's common sense. You want to be a citizen of Canada, you should have the intent to reside. But what it does, it creates two types of citizenship. The same obligation is not imposed on a Canadian citizen who's born here. They may, in theory, go and work overseas, for instance. They may have employment obligations or educational opportunities that they pursue outside the country, and they will still be considered a citizen. But somebody who applies under this new law now, uh, because they don't have the intention to possibly live here, or it may be challenged, it's a two classes. So that's one problematic area, even under the granting of citizenship rules. Another one is that citizenship can be removed, and this we'll get to in a minute in more detail, by a department official. So basically, it could be a political decision to not give you the citizenship without having a citizenship judge, evaluate as an independent body. So that in itself problematic. This was already in the books, as I said, from June 2014. Now, this piece of legislation came to our attention more recently because of the other provision, which came into effect just in on May 29, 2015. This particular provision of the Strengthening Canadian Citizenship Act, which had to do with revocation, that has attracted more attention now. Now, as I said, even the granting part, which came into law before, had issues, and I've identified two of the concerns that many people had identified, but the general public is not really aware of that as much as they should be. But the revocation provision, if you saw the editorial today in the Globe Mail, it talks about citizenship should be a right, not a privilege, even for a terrorist. Okay, very good editorial. I would suggest you have a look at it. It talks about the fact that we have now different classes of citizenship. So you have the Canadian born who does not have another nationality. These are true citizens under this law, and they have their most secure status. So there's no mechanism proposed for revoking their citizenship, even if they commit treason, even if they commit a terrorist offense or any of these serious offenses. Okay, so they're 100% protected. Canadian born who do not have another nationality. The second category are naturalized citizens without another nationality. Okay, so these are people who are naturalized under the current legislation, and the only way they could lose their citizenship is by if they misrepresent it in their application process. Okay, but of course, there are also another category, which is a Canadian-born citizen with another nationality. And so if you're a Canadian citizen and you have another nationality, then apart from misrepresentation, you are subject to revocation for a number of other offenses that you commit, primarily connected with terrorism, treason, joining an armed group. And these are all ill-defined. That's the problem with it, and I'll get to that shortly. But they're ill-defined. They're too broad. And it allows for political decision-making to happen when it comes to that. Now, with this category, the third category, Canadian-born citizens with another nationality, they may still lose their citizenship even if they don't have another citizenship. What do I mean by that? So let's say they end up marrying someone, and as a result of marrying that person, they could potentially apply for citizenship or nationality in this other country. Well, because you have that, under the way this legislation worded, you could have your citizenship revoked. Right? So that's very dangerous because you don't even know you may be qualified. There are many countries which allow, the children of or grandchildren of their citizens who may have no connection at all, they can actually potentially apply or qualify for it. And the wording and the Canadian Bar Association and various other groups highlighted this. This is problematic. The fourth category is, of course, naturalized citizens with another nationality. Again, these are individuals who may not know they have another nationality or qualify for another nationality. So these are truly third class citizens, because a whole range of revocation provisions can be used against them. So you can see this breaking down of citizenship right into different types. This is completely unknown to us, and it's this government in office has basically passed this legislation, and the way it's done, of course, is problematic. And how to challenge this is, in theory, yes, there's ways to challenge these things, but in practice, the cost factor involved in retaining lawyers and going through the process is very expensive and is beyond most people. The other concern with this legislation is it eliminates the requirement of federal court hearing for these revocations. In the past, there would be a federal court hearing held to consider whether or not this person misrepresented and they should have their status revoked. Now, this legislation does away with that. We've also removed a appeal route that used to exist to the governor and council. So let's say the federal court had upheld or called for a revocation. There used to be a provision where we could apply to the governor and council, who will assess equitable consideration, humanitarian consideration, and possibly not revoke. Well, that's been done away with this piece of legislation. So any kind of check that was there has been minimized or removed. Then another concern with this piece of legislation is it's the expanded grounds. So in the past, as I said, it was misrepresentation. Now we have terrorism, espionage, treason, and as well as you can have your status revoked if you are guilty overseas in another jurisdiction where you're charged with an offense which would be equivalent to terrorism and which would attract a sentence of more than 5 years. Right? So when somebody's assessing this, it's problematic because now we're opening this up, because terrorism, there is no definition of terrorism. What is terror? What is terrorism? We don't have an agreed definition. The United Nations has been trying, a number of people have been trying to come up with a definition. It's a political word, so of course it can be used politically. You also have the fact an overseas jurisdiction could determine that you committed an offense, which the Canadian officials, not a court, but a department head, minister, or some government official will decide that this is equivalent to a Canadian offense of terrorism. So we should be able to revoke this person's citizenship. So you have foreign people, foreign governments, perhaps undemocratic governments, deciding whether or not the Canadians could revoke your citizenship. So the door is wide open as well, the way it's drafted, to expand this group to anything that could be considered a threat to Canada, right? And so that's, red flag should be going up here, because anytime you have imprecise wording and a open forum like this, open avenues, you call it a basket clause in law, where basically it's a clause which allows you to throw in things because it's so broad. You have also another last concern I'd like to highlight with this piece of legislation is there's no appeal there's no appeal from any of these decisions. So minister makes this decision or department makes this decision, you go to the federal court, let's say, but there's no appeal to a court of appeal. So again, in theory, yes, all these appeal routes, sound very nice, but in practice, it's very, very difficult for people to go through this process. So to begin with, why have these changes been made without serious debate, without considering all of these issues, without taking into fact many of the take into account a lot of the submissions that were made by various entities. So and during question and answer, I can clarify some of the points on this piece of legislation. The next piece of legislation, which has a profound effect and that this government has pushed through, is the Anti-Terrorism Act 2015. So we had the Anti-Terrorism Act and various amendments right after 9/11, and then various amendments. And of course, the initial one was introduced by the Liberal government. Again, the fear, the reaction, It was an automatic kind of hysterical reaction. Even many criticisms of that piece of legislation. But some of the provisions had expired, and then now we had various amendments, and more recently Bill C-51 now has expanded many of the powers held by the Canadian Security Intelligence Service. So what are some of the problems here? Firstly, CSIS has been given powers beyond intelligence gathering. So we had a big controversy in Canada where the RCMP used to handle intelligence and law enforcement. And because they were mixing the two, there were all kinds of issues and problems encountered in terms of violations of rights, sharing of information, etc. And so there was an inquiry held, and a report was issued, and the recommendations from that intensive study was that these responsibilities, law enforcement and intelligence, had to be separated, and intelligence had to be more civilian with some additional oversights. So that was a scenario. But over time now, that scenario has significantly changed because the oversight that was there, which is the Canadian Security Intelligence Review Committee, has had its powers completely, minimized. You had a, much more robust mechanism system in place, review system in place. That's been completely minimized. And then we've now taken and given more powers to CSIS under Bill C-51, or this Anti-Terrorism Act. What kind of powers? Well, now they have a lot more in law enforcement powers. They can actually investigate. And the wording that is used is basically they can come in and they can disrupt. They can do many things that they could not do before. In the past, it was just intelligence gathering, and they would, analysts would evaluate this, pass it on to different agencies. If law enforcement needed to be engaged, then it will be passed on to the RCMP. And then, of course, RCMP is subject to many more evidentiary rules. With CSIS, you don't have these evidentiary rules. It's a secretive organization. By definition, they're going to hide everything. They may not be upfront with you. And that's the scenario here where you have intelligence now given all of these additional powers to operate like law enforcement. So that's number one. That's the biggest issue there is the powers given to CSIS. The Anti-Terror Act also creates a number of new offenses. So it's criminalized, quote unquote, terrorist propaganda and quote unquote, the promotion of terror. What do these mean? What does it mean to promote terror? And the way this legislation is worded, it's very problematic. And I'll read you a provision here which talks about this. So every person who, by communicating statements, knowingly advocates or promotes the commission of terrorism offenses in general, and that's an important word to remember, terrorism offenses in general, other than an offense under this section, while knowing that any of those offenses will be committed, or being reckless as to whether any of those offenses may be committed, and that part is important, or being reckless as to whether any of those offenses may be committed, as a result of such communication is guilty of an indictable offense and is liable to imprisonment for a term of not more than 5 years. Number of people have looked at this. The way this is worded, it would actually capture a columnist who is writing an article commenting on ISIS, for instance, right? Because if it's seen as, recklessly supporting indirectly or indirectly something that they're doing or promoting their stuff, you could technically be in trouble. In fact, a similar piece of legislation was passed in the United States. I think this is where some of these things come from, the ideas, and lawyers were afraid to start to represent people. So somebody's accused of terrorist offense, like, oh, would I be now contributing or promoting or supporting terrorism? And just in our offices, there was a charity which was shut down by the government for allegedly financing terror, contributing to terror. And in order to defend themselves, you need lawyers. You need to go through the legal system because you're battling against the government, which has a lot of power, a lot of resources. And essentially, what ended up happening was, and this is before Bill C-51, okay, this is before Bill C-51, we could not continue to represent this group because the Attorney General's position is, you know what, if you get paid, or all the funds belonging to this group has to be frozen. And so we said, how do we pay ourselves? Can we get an exemption to pay the legal fees? And we were denied that. So basically, the group has to roll over, cannot defend itself. The most violent criminals, a serial killer, etc., is entitled to a defense. Okay, but when somebody's painted with the brush of terrorism now, it's dangerous. And in this situation here, we ended up taking the matter to the federal court to say, look, this is not right. This organization needs to be able to defend itself. The federal court ruled against us and ruled in favor, because when national security is concerned, it seems like a lot of these normal rules and tests are kind of bent because they're afraid. They don't want to make the wrong call. Now, think about this. You have a system in a democracy where somebody's accused of being a terrorist, and this is prior to Bill C-51. So imagine now with this new tool that the government has, what kind of things, what kind of political speech, what kind of activism, what kind of supporting different things you can't do because you'll be caught under this. And some commentators, some law professors have written about this, that this wording could catch a columnist, and I'll read you the quote. Take just one hypothetical, and this is written by Professor Kent Roach and Craig Forsythia from University of Toronto and University of Ottawa Law School. Take just one hypothetical. An academic or foreign affairs columnist writes an opinion saying as follows: we should provide resources to Ukrainian insurgencies who are targeting Russian oil infrastructure in an effort to increase the political cost of Russian intervention in the Ukraine. According to the wording here, the speaker, and the speaker delivers this, knowing that there may be some people who support, who are sending money to those in Ukraine who are opposing the Russians. Well, according to this, the way this clause is worded, both these law professors conclude that the person who wrote this opinion could be charged, because the definitions of what is a terrorist activity, what offenses, what does it mean to support this, is loosely defined, it's ill-defined. So this is, again, very, very serious from perspective of political activism and doing political work and just basically exercising your civil rights. So that, again, is a restriction on free speech. Also, this new offenses of criminalizing of terrorist propaganda and promotion of hatred, no terrorist purpose is necessary. In the past, we have almost 14 different pieces 14 different provisions that make terrorism a criminal offense. In each of those, a terrorist purpose was necessary. Under this bill now, a terrorist purpose is not necessary. It's a you could be reckless, or you may have said something which kind of fuels it or contributes it. Again, that's extremely dangerous from my perspective. And also, under this new offense, may commit an unspecified terrorist offense, because the words I read to you, terrorism offenses in general. What does that mean? That's not defined. Terrorism offenses in general. Okay, and so again, very, very broad. Another thing that Bill C-51 or the Anti-Terrorism Act does is lowers the legal threshold to trigger detention. So they can detain people based on the fact that you may carry out. In the past, the wording used in the law, and I'll read it out to you, was a court official issuing this warrant or an officer acting on this believes on reasonable grounds that terrorist activity will be carried out. Now it's believes on reasonable grounds that terrorist activity may be carried out. So you're expecting judges who are supposed to issue these warrants and the police officer to be like a mind reader and say, well, this person may commit an offense. So you know what? It's better to detain this person. Again, this does not sound very democratic to me. And when I went to law school in the early 90s, if somebody said that they were going to have laws like this, I would not have believed it. Right? what a fundamental shift from, yes, if you know somebody, if you have reasonable probable grounds that somebody will commit a crime, yes, I can see a reasonable justification to possibly detain them. But they may commit an offense. And then it says, in the past, the detention or arrest should take place if it is necessary to prevent carrying out terrorist offense. Now the wording is, the arrest is, we should arrest or detain if this is likely to prevent an offense from being carried out. From necessary to prevent to likely to prevent. See, the standards are very different. And again, it's going to make it very broad. Now, I'm not saying that they're going to go around necessarily using these, but you never want to give powers to the government, because once you give powers, it's very difficult to take it back. And as you can see, anytime, sometimes even courts will make a decision against the government, but the government will constantly challenge it, pass new laws, and just tie it up. And then somebody will get detained or arrested. And then by the time they're cleared or something is changed, it's 5 years, 10 years, or however long it takes to go through the process. So the threshold is lowered. And a warrant to be issued if an offense is likely to be committed, you can see the potential dangers here of people. Who do you think, based on stereotypes and based on racial profiling, is likely to commit a terrorist offense? So, again, that's troublesome. Nextly, the Anti-Terror Act also extends preventive detention for suspected terrorists from 3 days to 7 days. And again, this is, there's no sunset clause provision here to say, look, is it even necessary? All of the disruptions and the arrests that have taken place in Canada have taken place without this piece of legislation, right? So was this really necessary? Are these things necessary? Will these things be abused? And my tendency is to believe that they will be. Once somebody's given power, they will use it when they need to, and so that's troublesome when they need to from their perspective. The Anti-Terror Act also legally entrenches a no-fly list. We had the Passenger Protect program, which was initiated in I believe in 2009 or so. What are some of the problems with this? Well, basically, you have government officials deciding to put people on a list without due process, without the right to a fundamental right to a hearing, and they put you on this list, and it's very difficult to come off. In theory, yes, you can come off of this list, in theory. But in practice, it's very, very difficult because, the Office of Reconsideration, where you make an application to, will again decide without you having a proper formal hearing, and possibly relying on evidence that's considered secret. Because this provision basically, the no-fly list provisions basically have included or have incorporated some of the draconian Immigration Act provisions, which talk about secret evidence. So if that's the scenario, you have somebody being put on a list based on information that's kept secret, that may have come from foreign sources, okay, who definitely may not have even whatever little checks and balances we may have here on this scenario, in this context here. And so you're on this list and you can't come off, and you find out when you show up at the airport. I've had numerous people call me at the office where they show up at the airport and they're told that they can't fly. And then they have to go through the process, and many times it's not even useful because information is provided by entities which you can't challenge, because there's no proper hearing process and cross-examination of the evidence. Another thing it does is this piece of legislation, the Anti-Terror Act, it grants government agencies explicit authority to share private information with domestic and foreign entities. We know from the Maharar fiasco that when our government passed information on to the Americans, which then passed the information on to Syria, etc., it resulted in torture of our citizen. So this, and the Arar Commission findings had recommended many recommendations to improve this, to prevent this, to curtail this. And instead of trying to implement those, what do we do is we pass this piece of legislation which basically says, you know what, we can continue passing information. And so again, this is troubling. A few of the recommendations were implemented, but again, not all of it or not most of it. And we still have now with this new power to share information to whoever, people are going to end up in a lot of problems. And again, we can come back to Bill C-51 during question and answer session. Next, I want to move to the Zero Tolerance for Barbaric Cultural Practices Act. It's not really national security related directly, but I think it contributes to the Islamophobia out there, which allows the government to then do these other things, right? Because of course, if you create the fear of the other, us versus them, and create all the xenophobia, and then it's much easier to pass through these pieces of legislation because at the end of the day, people think most of these legislative initiatives that have taken place in the national security context, I think doesn't apply to them. It applies to everyone, and it'll eventually will apply. They talk about national security law creep, the creeping effect of this into all kinds of things, and so that's going to happen. So the zero tolerance for barbaric cultural practice is a completely useless, unnecessary piece of legislation. Who in their right mind is going to be opposed to uh, to something named like zero tolerance for barbaric cultural practice at the surface level? Everybody's against that. But the way the reason for this and the way it was marketed and the way the language that's used, it's specifically to target immigrants and particularly the Muslim community. You know, uh, the initiatives that are or the changes or the legal issues raised in this piece of legislation: polygamy, making it illegal; forced marriages, making it illegal; uh, you know, banning. I don't know how they do this, banning honor killings, etc. These are all illegal as it is in Canada. The way this is, if you read people commenting on this, yes, it's about time we stop these things, as if these were legally permitted. They're already illegal. Polygamy is a criminal offense, although it is openly practiced. It's of course practiced secretly in among many Muslims, among not many, but some Muslims, and it's also openly practiced, by non-Muslims, the bountiful community. In fact, the charges were laid against some individuals connected with that community, and then they were withdrawn because the advice that was given to them was it may not stand up to constitutional muster. But the fact of the matter is, it was projected as if this is, it's all these immigrant Muslims who are coming here, and they may have multiple wives or they may get married here, and so we want to stop that. And then forced marriages and honor killings. The provision on honor killings, like who thinks that honor killings are legal in Canada to begin with, even prior to this legislation? What they're trying to do is when somebody is charged with murder, they raise all kinds of defenses. And this piece of legislation is actually very similar to all the anti-Sharia, quote unquote, anti-Sharia legislation that have been circulating in the United States, right? Various states, many of the states that did end up passing it, some of them got challenged through the courts, and the courts struck them down as unconstitutional because basically it's unnecessary, number one, and number two is targeting a particular community. So this is very similar to that, because what it's doing is highlighting things that supposedly Muslims do, and then of course they didn't want to use that word in there specifically because it'll be obviously discriminatory. So what they did is they used wording to suggest this is, we're against all these barbaric practices. And coming back to the provision on honor killing, what it is when somebody's charged with murder, they use all kinds of defenses. And any criminal lawyer will tell you there's all kinds of defenses that are possible that people will use. And one of them would be that, in my social circle, this thing would be considered so bad, so I reacted this way. So it's not justifying saying that's okay. It's a way to assess defenses. And a criminal lawyer will tell you there's all kinds of defenses that people will raise. Whether they succeed or not is another issue. A judge and is going to evaluate this. So sometimes people use, oh, you know what, this was heat of the moment, and most of the killing in domestic situation is not done by Muslims or immigrants. You have thousands, and I believe the Gold Mill did a piece on this. Thousands of women are killed all over North America by their partners. right? And they used that defense that this was, I just rage. It's at the heat of passion, crime, etc. And so this is really nobody's going to argue or deny that these things need to be addressed. But the way this was done, it's specifically to target the Muslim community, to contribute to Islamophobia, to help these other things along. Last piece of legislation is the Oath of Citizenship Act, which is a bill introduced. It has not passed yet. But even prior to this bill passing, and this basically the Oath of Citizenship, and I'll wrap up with this. The Oath of Citizenship Act basically says mandates that citizenship applicants must show their face during the Oath of Citizenship ceremony. So I think all of you are probably aware of the case of Zunera, where she was prevented from taking the oath with her niqab on. And this law is not passed yet. This is a bill. But prior to this, in 2011, Jason Kenney had introduced a directive to the government entities responsible for this to say basically, look, they need to show their face at the oath, not for identification purposes. And this is one of the misinformation that's out there. That I even had a chat here in the U.S. with a law professor, and he's like, I think they should show their face for identification purposes. And so I had to say, well, they do show their face for identification purposes. This has nothing to do with identification purposes. This has to do with during that public oath, this person has actually said they will show their face even privately for identification purposes, and will even show it to a private official during the ceremony, but not in public. And so he's like, oh, okay, that's not the impression he had, right? Because this is out there that, these people don't want to show their face, period. And you know what, this is danger, this is a security issue, etc. So this piece of legislation basically said that during the ceremony, and of course we know the federal court struck that down, and it went to the Federal Court of Appeal. The Federal Court of Appeal also struck it down, and now the government is appealing the decision to the Supreme Court of Canada. What a complete waste of taxpayer money. This is something that really this government is pandering to certain groups that support it, for doing these things. And again, anybody who analyzes this issue from a constitutional perspective, from a religious rights perspective, from a respect of the court's perspective, let's say you think this is not a religious rights issue, this is a security issue, which it isn't, because the person is willing to show their ID. But from a democratic, non-religious perspective, even, this is an issue of respecting the courts. Here you have the two courts. You have the first level court, and you have an appeal court, basically telling the government this is wrong. And yet this government is saying, nope, we're still gonna do. So they've tabled this piece of legislation, and they've promised here. The bill has not passed yet, but the government spokesperson told the Toronto Star that it is one of a series of bills being introduced now, which will together form a substantial legislative agenda after the election. So basically, that's speaking to a certain constituency here. Look, don't worry, we've got a whole bunch of these things in the works for you, right? So we haven't passed this yet, but you know what? Get us into office, and we'll show you what we're going to do for you. So again, this is very problematic, and all of this is going to affect, and this is not just me saying this or some human rights activist saying this, various prominent jurists, ex-justice ministers, judges, etc., have all signed on documents and published, opinion pieces, etc., saying that this is going to impact the Muslim community, but eventually impact everyone else. That's what happens, And I'll end with one final example from the national security context, which I like to use because it demonstrates the ability that something you think is only going to be used against someone else eventually gets used against you. And I'll talk about the U.S. context. So when drones were first used here, nobody objected because drones were, they're just doing for surveillance. It's actually helping our troops. And so, yeah, no problem. Who's going to be against that? Then they said, we're going to go after overseas targets, foreign targets, and they're terrorists. Okay. Now, of course, many people didn't really care. Those who were concerned about rights and due process, I said, well, hang on a second. How did you decide this person was a terrorist? You just decide that based on intelligence. Somebody may have just not liked that person, may have told you this person is a terrorist, and then you go and take them out using a drone. But most people didn't care because it didn't affect them. Then they said, oh, you know what? We can also do the same thing to American citizens. Now, more Americans woke up and said, oh, hang on a sec. we'll first use it for surveillance. Then it was foreigners. It was bad, but you know what? We were okay with it. Now you're going after American citizens. More people spoke up. But then they said, you know what? Now we're going to use this to do surveillance against you in the United States. So various states now and police forces are using it, using drones. Now people are, oh, hang on a sec. Why is it affecting me? This is national security creep. Once you give the power to the government, it may be used against specific groups first, but eventually it's going to expand. So even from a selfish perspective, if you're not a human rights activist and you don't care about other people's rights, which you should, but some people don't, you should think of this from your own selfish perspective, that this is eventually going to come to you, right? It's only a matter of time once they taste this power and they use it, they'll be the same thing happened in the surveillance context. It was only used against specific groups, expanded, and now there's massive surveillance. And now we see people now raising the issue. So with that, I would end my presentation and then open up the floors for any questions, clarifications, comments, etc. Thank you very much.
Thank you, Faisal. I'm sure you meant all of this in the non-partisan, most non-partisan part of way, right?
Of course, of course.
I think it's
as much as I could be nonpartisan. I have to state the facts as well.
Well, I mean, it's one thing being against a certain party, another thing being against certain policies, and of course they're not completely distinct from each other. But certainly the three parties have different positions on any of these policies that you mentioned. The Liberals support some, not the others. The NDP are against, I think, most of them. I mean, the Arab and Muslim communities have suffered since 9/11 from these types of national security initiatives, policies. The scrutiny affects these communities more than it affects other communities, obviously, and I think it's natural for members of these communities to be concerned, and to because they're likely to feel the effects of these laws more than anyone else. Back to you, Rula.
Thank you, Dr. Kutty, for a very informative and very revealing set of points. Perhaps I'll kick it off by asking one question, which is probably on people's minds, and that is we've had a lot of debate about some of these security issues in the election campaign. A lot of commentary, and I'm wondering if you can sort of summarize for us what the different parties' positions have been, and also not just the politicians and the parties, but also the legal community and any other important civil rights groups. If you could sort of give us a broad overview of the reaction to some of these security issues.
Okay, so basically with the Anti-Terror Act, as Raja mentioned, the Conservatives have introduced this piece of legislation. It was building on legislation that was introduced right after 9/11 by the Liberals. They were criticized for many of the things they did, and some of the provisions kind of sunsetted away. Then amendments were brought in later, subsequently, and now this new government has introduced Bill C-51. The Liberals supported it and have basically said that if they get into power, they will make some amendments and repeal some provisions, etc. Again, that remains to be seen after they get into office. With the NDP, they basically said they're against this and they're opposed to the Anti-Terror Act because of the overreach and the lack of oversight, etc., which we talked about. And I believe the Green Party as well is against it. Bill C-24 as well, which is the Strengthening Citizenship Act. Again, the Liberals are against it, and the NDP is against it as well. So again, we may see some changes there. There's some provisions the Liberals have agreed to, but they have some problems with some of the provisions. In terms of this, groups out there, I mean, the various legal groups, the Canadian Bar Association, uh, various civil societies, BC, British Columbia Civil Liberties Association, um, you know, other rights groups have all come out basically critiquing these things. And there's various position papers out there. If you Google any particular of these groups, you'll see policy papers on all the pieces of legislation that I talked about. And interestingly, with the Barbaric Cultural Practices Act, which is not really national security, as I said, but it contributes to Islamophobia, um, many of the women's rights groups came out against it because it said it's kind of, trying to diffuse the issue. It's not really dealing with the issue the way it should be dealt with. So that was interesting to read from their perspective as well.
Thank you. I have a question from one of our participants. Question is as follows. So under C51, an individual can be charged and convicted for promotion of a terrorism offense, for promotion of terrorism, right? Can such a person's citizenship be revoked under C24, or does it only apply to those convicted of terrorism as opposed to promotion of terrorism?
Good question. The way the legislation is worded is, it's very broad under C24. It's very broad as to what is entailed, and it's wide open. And some of the concerns expressed by various people who commented on this, BC Civil Liberties even identified this as, it's going to go beyond just a terrorism offense. And if you're convicted under Bill C51, that's what you're basically promoting terror. That means you're guilty of a terrorist offense, right? Because it says espionage, treason, terrorism related offense, and then it's broader than that as well, right?
Mhm.
And so you have they have the possibility of being included in that group to have your status revoked.
So folks, feel free to go ahead and pose questions in the chat window. I'll take one or two more questions, and then we're going to stop the recording, and we will be able to have a free-flowing discussion where you can pose your questions yourself. I had a question here regarding the niqab ban. So regarding the niqab ban, similar to strategic voting, shouldn't Ms. Zunera strategically hold taking the niqab issue to court during a federal election? Unfortunately, it seems the issue in the media is only drumming a hate anthem against Muslims, allowing left-wing parties to lose popularity. Would it be unfair for the Muslim community in the GTA to request Ms. Zunera and other women to withhold any grievance until after the election?
Interesting question. So, I mean, that's not for me or any of us to decide. I mean, it's her, it's her fundamental right. So the charter has protects one's religious rights. The Constitution protects one's religious rights. The Supreme Court of Canada has said that what someone considers their religious is what their conscience. They personally, sincerely, it's a sincerely held belief. So, yes, there's debate within the community whether or not this is something that that we should be championing, etc. But if you're looking from a principle point of view, if you take democratic votes, this is the problem. If you take democratic votes on many things, many practices would continue. So at the time of slavery was banned, right? If they took a vote, a majority vote would have said, no, we need slavery. It's great. But it was seen as a rights issue, right? So in this case here, it's not the same thing, of course. But for her, she sincerely holds this as her religious liberty issue. From a community perspective, yes, strategically, maybe it's not the best for our community, but I can or you can't tell her, look, hold off on this. You know what? You don't go for your citizenship today. Now, because the Constitution and the court has said that she is right. So why are we faulting her now? We should be faulting the government, say, look, you're disrespecting the court. You're supposed to be respecting the judicial decision. If the court said, no, you're right, less people would support her then, right? But I can't make the call for her to say to her, look, you should hold off on this, because that's her decision she makes. As I said, from a community perspective, it may not be the best move, but that's her call. I can't really comment on that.
I think if I may interject here, I think we need to be able to make a distinction between one's personal views or feelings about the niqab and a person's right to religious freedom. You know, many people say that Islam does not require you to cover your face. That's not the point. The point is, if she has the sincere belief, and that's the language used in human rights law, if she has a sincere belief that this is what her religion requires her to do, whether Islam or any other religion, then that right is protected under human rights law and the Charter of Rights and Freedoms. And there's no doubt in my mind that should this matter go to the Supreme Court, it will be the government will lose. Um, Unfortunately, this issue has been more political than anything else, and in Quebec in particular, and the number of women who are actually have been prevented from taking the oath of citizenship because they're covering their faces too. So
Yes.
all this hoopla is about two people. So you've got the government on the one hand and two women on the other hand. So it's sad. It's unfortunate that these things are happening. But I mean, I often say that since 9/11, it hasn't mattered who the government has been. You know, these same battles that are now we are dealing with in terms of Bill C-51, back when it was C-36, Faisal, if I'm not mistaken, was
Yes.
it
Yes.
36? It
Yes.
was
Yes.
also the Anti-Terrorism Act and so on. I don't, these are not necessarily specific to any particular party. It's the government of the day, and where it decides to weigh on or not weigh on. And for me, what that means is that we need to matter as communities, so that when policies are made, our views, our thoughts, our concerns uh, get taken into consideration. And for that to happen, the first thing we need to do is vote. I mean, that's the minimum that we need to be doing is vote. And again, I bring it back to the campaign that we have now, and it's about voting. It's about voting as a first step. Then become a member of the party that best represents your values and your interests. Volunteer, make donations, one day maybe even run for office. Why not? The good news is that that is happening more than it was in the past. We identified in this election campaign 22 Canadian Arabs running in the federal election, and that's a respectable number that I hope will continue to rise. We haven't specifically counted the Muslim candidates. There are of course, non-Arab Muslim candidates on top of that. But between the two communities, I think there's a rising there is a rising awareness of the need to engage, become citizens, become active. Otherwise, we will never see ourselves reflected in the policies of this country.
Thank you. So I have a couple more questions, and we're going to open it up for direct questions from participants. We have a question that goes as follows. Thank you, Dr. Kutty, for the clear explanation of your three acts. Regarding the Anti-Terrorism Act, C-51, it's a subject that comes up at dinner parties and with the usual arguments that you would expect. For those who may have not attended your webinar to learn more, do you have a dinner party answer to suggest to get them thinking more critically? So I guess somebody's looking for that elevator speech on this issue to very quickly get to the point and convince them.
Yeah, I mean, basically the Anti-Terror Act, Bill C-51, what it does, it gives powers to an entity which is a secret entity without oversight. Okay, so if in most other democracies, uh, you have a intelligence gathering group that's out there, but it is supervised. It's either accountable to a congressional committee in the United States, for instance, the CIA. Um, you have other to parliamentary committees that have oversight. Here, what's happened is the oversight has been removed, and I'll give you a quote that's interesting from one of the ex former former CSIS counterterror head, who basically said that all these changes in Bill C-51 is coming at a time when his name is Jeffrey O'Brien, CISA's chief of counterintelligence. He said that these fundamental changes, where intelligence is being given all these powers, is occurring at a time when Parliament has come under criticism for lax scrutiny of spying. So there's no scrutiny, and we've given more powers to them. So that's one big thing that should red flag anyone. Do you want to give powers to a secret group, which is not accountable to anyone in a democracy? The second thing is, do you want to give away? You want to give expanded powers of what is considered, supporting terror, right? It could be any political things you do. It could be some support that dissident support that you do against the government. That could be considered, sympathizing with the terrorist, right? So it's hard to give you like an elevator speech on it, but basically, the idea is you want to give powers to a secret entity without oversight, and you want to expand the powers given to this organization to arrest and detain people without the accountability.
Okay. And the last question is, how difficult would these laws be to repeal, provided there's a new party or a new parliament, a different parliament, a different ruling party or coalition?
Well, I guess it depends on the political will, right? On once they get into power, I mean, the NDP says it's going to repeal it. Some people say, well, they say that now, but it may be very difficult for them to do it. Same thing with the Liberals; they say we may amend certain provisions. Again, we won't know. But is it doable? Yes, it is. But will there be the political, the political backbone, the political willingness and motivation to do it? That's another thing. Once this election phase goes through, I don't know what happens afterwards, whoever is in power. And as Raja said, I agree. Many of the things, no matter who's in power, sometimes, there's this thing that because our communities don't speak up, because our communities are not involved, and we will be the ones who would continue to raise these issues. We should be the ones continue to raise these issues. If we're not loud enough, and if we're not visible, and if we're not pushing these things, maybe there's no motivation for the whichever party is in power to repeal or amend, etc.
For the purpose of the recorded webinar, I just wanted to thank you very much, Professor Kutty, for this excellent overview and answering our questions. I encourage everybody who's watching to go and take a look at our website, sign up for our emails, sign up in the Your Voice campaign. Definitely go vote, definitely inform yourself, and pick take positions and your votes based on what you've informed yourself about. And from there, I'll officially end this webinar. Thank you very much for the participants who joined us today. Thank you to the Your Voice campaign team and to Raja, as well as to Noor, our NCAR coordinator, for all their hard work in helping us to prepare these webinars and get everybody registered and able to join.